Thank you. Awesome. Okay, so today we're going to go over North Carolina buyer consultation. And we always want to make sure our buyers have all the information to make informed decisions. An informed buyer is going to be an easier buyer to work with, especially when it comes to difficult negotiations and idiosyncrasies that come up within a transaction. We all know that no transaction is the same. So it doesn't matter if you've got a first-time buyer or somebody who has purchased something, 10 times over. Each transaction is different. So reaffirming all of the steps and all of the things that go along with the transaction and everything we're going to do for them and our expectation of them with what we're going to do is always a good thing to do. In North Carolina, the first thing you're going to do is, here's a North Carolina buyer consultation checklist. You can see we've got quite a few required documents here. And that, again, it's just to inform the buyer, protect the buyer, and protect you as an agent as well. So the first step is this working with real estate agents disclosure for buyers. And it is not a contract. This is not your exclusive right to represent agreement. This is just the explanation of what buyer agency is in North Carolina. Buyer agency in North Carolina is a little bit different than it is in Virginia in the fact that they consider dual agency to be related within a brokerage, not just a single agent. In Virginia, a dual agent is a single agent representing both the buyer and the seller, and we all know we don't do that. In North Carolina, dual agency exists if the same firm represents both the buyer and the seller. So in North Carolina, your client needs to agree to dual agency, but then immediately demand designated dual agency, which means that they will have exclusive representation by their own agent. And if there is another agent within our firm that represents a seller, that is considered dual agency. So on this form, they are going to initial that they want buyer agency. They're going to initial that they accept dual agency because that could be two agents within our firm. And then they are going to state that they want that dual agency to be designated so that they know that they have their own agent representing their best interests. Okay, does that make sense? Any questions? And again, this is not the exclusive right to represent. This just explains agency in North Carolina. All right. So then we have our buyer agency agreement. And this goes through the whole gamut of what representation means in North Carolina. So again, at the top, you're going to use the buyer's full legal name because this is probably what the attorney is going to use to establish title. You're going to use the date that you're filling it out, and you're going to put that the firm is Keller Williams. Just like in Virginia, if the buyer is a corporation, limited liability company, trust, or other legal entity, that entity will be named as the buyer. So if it's ABC LLC, that's what goes in the buyer section. And then that representative of ABC LLC will sign, Jane Smith as a member of ABC LLC. This is how that gets signed. The buyer represents that as the commencement date of this agreement, the buyer is not working with not a party to another buyer representation agreement. Just like Virginia, we ask, are you under a buyer representation with another firm? And the buyer is saying no. The type of property most often is going to be residential, improved and unimproved. The general location, put city or county names, or if there's another location that is pertinent to this agreement, you put it there. The buyer intends to acquire real property, and they are employing us as our firm as their exclusive agent. And the buyer agrees in that exclusive agency to conduct all negotiations for the property through the firm and refer to the firm for all inquiries received in any form from other real estate firms. So that's a good thing to point out to them, is that, you know, if anyone else approaches you, if anyone else has any ideas for you, have them contact me. I'll be happy to talk to them. The term of the agreement, it usually will begin on the date you're filling out the form, but in North Carolina, because you can have conversations about real estate and you can do your agency disclosure form ahead of filling this out, you can backdate this and it will go into effect, you know, from, if you talk to them and had them fill out that disclosure form a week ago, you can put a week ago's date on there, but it's okay to use the date you're filling out the form as well. And you're going to check the appropriate box for buyers who intend to purchase a single property, and then the date which the agreement will end, or buyers who may purchase more than one property and you may extend it out. You may have an investor who's planning on buying 3 or 4 things and you want to keep them on the hook for a year. Then you go ahead and check the bottom box. If it's just somebody looking for their own primary residence, it's just going to be a single person purchase, and you may only need them under this exclusive agreement for 90 days or 6 months. We do not take a non-refundable retainer fee, so you're going to fill in 0 under 4A. And then the buyer agrees to the firm's fee for services here under the amount of 3%. Now, again, we're in a bit of a different market. You can put as per MLS. If the buyer is hesitant about the 3%, that's your business and your agreement with the buyer. If you agree that it's going to be a hard and fast 3% and they purchase a home where the MLS says it's 2%, then the buyer is on the hook for that other 1% of your commission. All right. And all of the legalese that goes with that. The firm shall seek the fee from a cooperating listing firm as through the MLS. And like I said, if the buyer purchases a property where the compensation offered is less than the fee, or where no compensation is offered, then the buyer is obligated at that point. And again, that's between you and the buyer. You set up your expectation, you establish your role and your rules, and you move forward with that. Buyer initials at the bottom of the page, the agent initials at the bottom of the page. We had additional compensation. Sometimes there's a bonus in the MLS. So that additional compensation is done in writing and has to be disclosed. You don't get to take a bonus and nobody know about it. Then we have the circumstances under which your compensation shall be deemed earned. And that is if the buyer directly or indirectly enters into an agreement to purchase and or exchange any property of the type described in this agreement, regardless of the manner in which the buyer was introduced to the property, or if we're recommending 90 days after expiration of this agreement. If you want to extend it out to 180, that's fine. That means if the buyer enters into a contract to acquire the property introduced to the buyer during the term of the agreement by the firm, unless the buyer has entered into a buyer agency agreement with another firm. So if they just go and think they're going to save money by purchasing directly through the listing firm and they're not under an agreement with them, then you're protected for that commission. Compensation due and payable at distribution of proceeds, just like in Virginia, it's done at closing. I love these little blue boxes on the North Carolina stuff. It's stuff that they want everybody to be aware of. Buyer understands and acknowledges that there is potential for conflict of interest generated by a percentage of price-based fee for representing the buyer. The amount, format, or rate of real estate commission is not fixed by law, but is set by each broker individually and may be negotiable between buyer and firm. So that's just saying that we don't have any hard and fast rules for commission. If the buyer does not pay the commission, or you don't receive your commission as stated in this exclusive agreement, the buyer will then, the firm will be entitled to recover attorney fees and court costs from the buyer. If we have to go after the buyer for any commission, then the buyer is liable for those attorney fees and court costs as well. If the buyer purchases unimproved property, the agent may assist the buyer in identifying a contractor to make improvements on the property. And the buyer acknowledges and understands that in such a case, the contractor may offer to compensate the agent as well. And again, you have to disclose to the buyer the existence of such an offer of compensation before the buyer enters into the contract. And this alerts the buyers that there may be other prospective purchasers represented by our firm that want that same property. And they just have to understand that there are limited properties and many buyers, and you may or may not get beat out by somebody in the same firm. Then we go into the firm's duties. And during the terms of this agreement, the firm will perform the terms of the agreement. They will seek a property at a price and terms acceptable to the buyer. They will present in a timely manner all written offers or counteroffers to and from the buyer. Disclose to the buyer all material facts related to the property concerning the transaction for which the firm has actual knowledge. We don't go into supposition or guessing or assuming. This is actual knowledge. Account for in a timely manner all money and property received in which the buyer has or may have interest. And the firm shall maintain confidentiality of all personal and financial information. And again, in satisfying the duties, the firm shall exercise ordinary care, comply with the laws and regulations, and treat all prospective sellers honestly and not knowingly give them false information. And again, noting that the firm may show the same property to other buyers and represent other buyers and sellers relative to other properties, provide assistance to a seller or prospective seller by performing ministerial acts. That would be, in the case of a FSBO, you would be representing the buyer, but you may be helping with contract documents for sale by owner. And then upon closing of the sale of the property that is not entered into a listing service in which the firm is a member, buyer authorizes the firm to submit pertinent information concerning the property sales and sales price to the listing service. So that's what allows you to get that property logo added into the MLS if it was a for sale by owner, and allows you to get credit for the property. And it also helps other MLS members with their pricing and ability to see what sales have happened. Disclosure of buyer's name and mailing address. And unless otherwise stated in paragraph 13, firm has buyer's permission to disclose buyer's name. In accordance with North Carolina general statutes, if a dispute regarding the return of forfeiture of any earnest money deposit arises between the buyer and seller of any real property, buyer may agree to purchase between the buyer and seller of any real property, the buyer may agree to purchase. The escrow agent holding the deposit may deposit the disputed monies with the appropriate clerk of court following the written notice to the parties. So this is just stating that if there's a dispute over that earnest money and nobody can agree and the escrow agent doesn't have a clear path forward, it goes to the court for a decision, same as it does in Virginia. Again, Keller Williams does not hold earnest money, So it's already going to be sitting with an attorney who's likely going to have all the knowledge they need to be able to move forward with dispersing any funds from a canceled contract. Initials again at the bottom of the page. Big and bold, that means it's important. The agent and firm shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, realtors have an ethical duty to conduct such activities without respect to the sexual orientation or gender identity of any party or prospective party. So you're just fair housing, you're just treating all people fairly. This is warning buyer letters to the seller. Personal letters to sellers expressing why the buyer wishes to purchase the seller's property is a tactic sometimes used to attempt to make a buyer's offer stand out to the seller. Such letters often contain personal information and reveal characteristics of the buyer, which could be used knowingly or through unconscious bias as a bias for the seller's decision to accept or reject an offer that might violate state and federal fair housing laws. In order to avoid potential liability for unlawful discrimination, as well as the appearance of impropriety, the buyer should discuss with the firm how any such letters will be handled. Holly, you want to chime in here on buyer letters to the seller and what your thoughts are? Hello? I guess not. Okay, so I think the prevailing thought now is that it's not a good idea because those letters could tend to give away more information than the seller needs to make a fair decision. So if your buyer's adamant, just make sure it doesn't reveal too much personal information and move forward.
The biggest thing is just not to offer that as an option, because most buyers these days aren't going to say that, but don't offer that as an option.
Right. Yeah, it's just not a best practice at this point in real estate. The buyer's duties. Buyer agrees to cooperate with the firm in the acquisition of real property of the type described in paragraph 1, including but not limited to working exclusively with the firm during the term of the agreement, immediately referring to firm information about any properties buyer may have interest in examining, complying with reasonable requests of the firm to supply any pertinent financial or personal data needed to fulfill the terms of the agreement, being available for reasonable periods of time to examine properties, examining properties only by appointments made through the firm and accompanied by an agent of the firm, conducting all negotiations and communications through the firm, conducting all due diligence on property in consultation with the firm, and paying for all products and services required in the examination and evaluation of the properties. For example, surveys, water soil tests, title reports, property inspections, etc. Other professional advice, in addition to the services rendered to the buyer by the firm under the terms of this agreement, buyer is advised to seek other professional advice in matters of law, taxation, financing, insurance, and blah, blah, blah. Keeping in mind that we are real estate agents and real estate agents only. We do not have law degrees. We are not licensed inspectors. We don't know engineering of buildings and that sort of thing. So stay in your swim lane, do your job, and have a pool of people who are reliable and responsible that you can refer your buyer to. And again, firm cannot guarantee the quality of service or the level of expertise. The buyer has to do their due diligence. Buyer agrees to pay the full amount due for all these services to the provider, regardless of whether or not the transaction closes. I like that. It puts them on notice that it doesn't matter if you actually purchase this property. These are fees that are part of the process. And then they'll hold the firm harmless from any liability claim, loss, etc. Then we've got 3 documents that are to be given to the buyer so that they have these items to review and get familiar with. These items are available in Brokerment. Please have your buyer initial the front page of each item and put it in Brokerment for review. This is another protection. We're informing the buyer, we're educating the buyer, and we're protecting you and the firm. So the buyer is going, you're going to check all three boxes. The buyer is going to acknowledge the receipt of a sample copy of an offer to purchase and contract. The buyer acknowledges the receipt of the brochure, question and answers on home inspections, and a sample copy of the professional services disclosure and election form. So again, you're going to give those forms to the buyer. You're going to have the buyer initial the front page, and it's going to be loaded in Brokerment. And we are going to always inform our buyers so that they've got all the knowledge they need to go forth and make a beautiful purchase. Home warranties. The seller may or may not provide a home warranty as part of the sale. If the seller does not provide a home warranty, the buyer may elect to purchase one, and the buyer understands that although the firm will assist the buyer in identifying home warranty products, the buyer must refer specific questions regarding coverage afforded by any such product to the provider of that product. If the firm assists the buyer in obtaining a home warranty, a fee of blank will be offered to the firm. We don't take a fee for referring our people. We just work with good people and make sure that our buyers are taken care of. Confidentiality of offers. Real estate brokers are prohibited by North Carolina Real Estate Commission rule from disclosing the price or other material terms contained in a party's offer to purchase, sell, lease, rent, or option real property to a competing party without the express authority of the party making the offer. However, sellers may not elect to treat the existence of terms or conditions of any offers the buyer make as confidential. So it's a little. Sellers may or may not elect to disclose or authorize the seller's agent to disclose the existence of other offers. Same as we have here. You can go in and say, do you have another offer? What do I need to do to put my buyer in the best position? That listing agent is probably going to say, yes, we have other offers. Bring me your best. They're not likely to disclose what you need to do. So you and your buyer have to determine what that best offer is, but you're not going to let the other agent know what your buyer's buying power is or what their thoughts and plans are. And then in additional provisions is where we put our Keller Williams administrative fee. So you make sure that that's in that spot, and both parties, the buyers and the agent initial at the bottom of the page. Here we go into the dual agency. And again, the dual agency in North Carolina is a little different. Dual agency comes into play when two agents in the same firm represent the parties to the transaction. So we're going to agree to dual agency, but it's always going to be designated dual agency. So that comes, I mean, this is all of the rules, same rules, confidentiality, buyer and seller don't know what each party is doing, but we are going to initial this top line where the buyer authorizes the firm to act as a dual agent representing both the buyer and the seller subject to the terms and conditions set back in paragraph 14. But we're going to add the initials under E saying that we are designating individual agents, one for the buyer, one for the seller, and they shall not divulge information and maintain confidentiality for their own client. So again, Keller Williams does not allow single agent dual agency. So if you thought you were going to be able to represent a buyer and a seller in a transaction, you would need Thomasina's blessing in writing and have that loaded into Brokerment in order for that to move forward. And it's going to be a slim and none chance of that happening. So find a friend, make a referral, have designated agency, and everybody stays happy. Buyer initials at the bottom of the page, individual agents initial at the bottom of the page. Another pretty blue box. When dual agency arises, an individual agent shall not practice designated agency and shall remain a dual agent if the individual agent has actually received confidential information concerning a seller client of the firm in connection with the transaction, or if designated agency is otherwise prohibited by law. So you could run into a problem if you're friends with the listing agent and they have talked to you about things. You may need to step back and again refer this buyer client. If you have knowledge of something within that listing, you may need to step back, refer the buyer to someone who doesn't have knowledge of anything within that listing, and take the referral fee and let the designated agency stand. If the firm acts as a dual agent, we expect to obtain the full commission, both sides. We're not discounting our commission for representing both sides of the transaction. Mediation, again, if a dispute arises, the buyer agrees to try in good faith to settle by mediation before going to court. Agreement changes or terminations. This agreement constitutes the entire agreement between the buyer and the firm relating to the subject thereof and any prior agreements pertaining thereto. All of the legalese. It means that this agreement may not be, although the buyer may at any time withdraw their relationship between the buyer and the firm, the contract created by this agreement may not be terminated by the buyer or the firm prior to its expiration date without legally sufficient cause. So I'm not sure what they consider legally sufficient. I mean, the buyer could say, you're not showing me the properties I've asked you to show me. You're not upholding your part of the agreement and I want out. So any termination will be mutually acceptable written agreement signed by both the buyer and the firm. So this is going to need the firm's signature, not just the agent's signature. And another note to the buyer should consult with the firm before visiting any resale or new homes or contacting any other real estate firm representing sellers to avoid the possibility of confusion over the brokerage relationship and misunderstandings about liability for compensation. This comes into play a whole lot with buyers going to new construction places. If they get all excited and they go tour the model home and all of a sudden they're thinking, oh, this is the place, and they go sit down and talk, and they have not yet mentioned that they are under a exclusive buyer agency agreement with our firm, then we have misunderstandings. And new construction is notorious for squeezing out the buyer's agent. So make sure your buyers are fully informed on the fact that they are represented. If they go to an open house, if they go to a model home, they need to have a stack of your cards with them. They need to say up front, I'm represented by this agent. I am under contract with them. They are due a commission if we do anything, and I will be going to them to put together any offer of purchase. Don't let another agent start, make sure they know not to let another agent start any kind of a contract situation for them. We just went over this at the sales meeting about the surveillance. Buyer is advised to be mindful of the fact that there could be video, audio surveillance devices located on the property, and that they may be under surveillance during any such examination. Federal and state laws prohibit the interception of an oral communication through the use of any electronic, mechanical, or other device, whether or not recorded, without the consent of a party to that communication. Again, video surveillance without consent is not legal. So like we talked about, when we list properties, I think we agreed that we're going to put in both the public and the agent remarks that cameras that do both audio and video are on the property, and anyone who enters should be aware of that. And by entering, then they have given consent. And again, unless a property owner has notified the public that photography and video recording is prohibited, it is permissible to photograph or video the interior of a private property, since the owner's permission to enter the property implies the permission to do so. However, you can't take photographs or videos that intrude on a property owner's reasonable expectation of privacy. So don't open the underwear drawer and get pictures of whatever's inside there, because that's just not that. I mean, that would fall under reasonable expectations of privacy. Only things that are in plain view. And here we go. Taking a photo or video of contents of a medicine cabinet or financial records in a desk drawer would be impermissible. And again, buyer acknowledges and understands that neither the firm nor its agents have control over information about any property the buyer may purchase that has been placed on the internet in connection with any of the marketing of such property for sale, whether by through a listing service or otherwise, including but not limited to photographs, and that any information will not be removed following the buyer's purchase of such property. So those pictures that were on Zillow, those pictures that hit realtor.com, they may stay there for the duration of that entity, and the buyer needs to be aware that those things are just forever out in the internet. Initials of buyers and the agent at the bottom of the page. Wire fraud warning. Again, big, bold, all capitals, red outline. It's important. Make sure the buyers are aware that there are scammers out there, and they're really good, really, really good at imitating attorneys and title companies, and always pick up the phone and make a call to verify the wiring instructions, and never trust when if they get something saying they've been changed, because it's likely a scammer. And the second paragraph releases the firm from any kind of liability regarding that. Buyer and firm hereby acknowledge receipt of a signed copy of this agreement. So the buyer is going to sign and put out their contact information. If they're an entity, this information is filled out. And then the firm information is filled out, and the agent signs it, and your license number needs to go on there, and your phone and email. Don't hold back the information. Make sure it's all on there. Okay. Any questions about the exclusive buyer agency agreement? It's a little more robust than what we have in Virginia, but it covers all the things. Okay. And then we have our internal forms that are still going to be used. You're still going to have them fill out, or they're still going to sign our cybersecurity notice, which is just going to reinforce that need for extreme diligence when it comes to wiring funds and making sure that you've got the proper information for that. So this is our firm form that we use in Virginia. It's also used for our North Carolina transactions. So please make sure that they sign that. And then we have our escrow agency notice, which explains to them that Keller Williams does not hold earnest money. So we're going to name the the attorney or title company who's going to hold the earnest money, the contact and phone number. And that way the buyer knows where they need to go should there be an issue with their escrow money. And then North Carolina puts out all these lovely, lovely pamphlets that are very informational and quick and succinct. And then if they want to see more, they've got the lovely QR codes. So this is loaded into Brokerment for you. It answers the questions that are most pertinent regarding home inspections. You're going to provide this to your buyer, and you're going to have them initial the top of the page, just so that you can show that they have seen it. Further on down the road, when it comes time for the inspection, they're going to say, but you didn't tell me this. And you're going to say, yes, I gave you the pamphlet. We went over this, you initialed it. So again, it's another layer of protection and another level of information and education. We want to fully educate and inform our buyers always. So that's the home inspection one. It is required. The lead-based paint pamphlet is the same. It's the EPA booklet. Yeah, I don't have a copy of it here, but you should be used to seeing that in the Virginia forms. Sample offer to purchase. This we checked off in the buyer agency agreement that we were providing them a sample offer to purchase and contract so that they can get familiar with what the document looks like. So we're giving this, it's marked sample. They're going to initial that they have received it and have time to look at it before they put in an offer of purchase. Because just like us, they have a 15-page contract, lot to go over, and having them a little more familiar with it before they actually write an offer is always a good thing. Holly went over this in detail last month, so you can go to YouTube if you need more information regarding how this form works and the idiosyncrasies and ins and outs of this form. So that's there. The sample professional services. This is also a lovely little form that gives the buyer all the information about who to use, who you recommend, whether this is a recommended option for this purchase. They may not always need all these people, but if you've got a home inspector and if they're waiving it, they're going to initial it. If they're going to have a home inspection, they're going to initial here, who ordered it, and the name of the provider. Just another set of checks and balances. You're going to provide this to them as a sample prior to contract so they can review it and have the information regarding radon. I don't know how much radon testing actually goes on in the areas of North Carolina we would work in. Mostly it has to do with basements and stuff, and I don't know that we are far enough inland dealing with that for a lot of radon, but it still could be an issue. Surveys and other notes. And it lets us off the hook that the firm doesn't guarantee the quality of the service. The buyer needs to do their due diligence and, look on Yelp, check Google reviews. And, obviously, if you've worked with service providers and you've got a good list of 2 or 3 that you can offer them, then they can interview them and make their educated choices. And then their pre-approval letter, always required pre-approval letter from your lender so that everyone's aware what they can qualify for and what they're shopping for. And then we have all these other lovely pamphlets. They're all in broker mint for you. The ones that are required are marked as required. Just like in Virginia, we've got the package, we've got marked for you which items are required. So there's no guessing. And all of the pamphlets are in there. Feel free to provide all of them to your buyer at any time to go over. Offer and acceptance pamphlet. This further explains the purchase agreement. I don't know that I have a copy of it right here, and I don't think opening it here actually gives me it doesn't show it to me now. So please take advantage of these pamphlets in North Carolina. I think they're wonderful. They're quick and easy, knowledge base kind of question and answer things. And if nothing else, it gets a conversation started and gets the buyer thinking and gets them able to ask more questions that can help them with their purchase. So that is buyer agency in North Carolina. Do you have any questions, anything I can help you clarify? Thomasina, anything else to add?
No, that was pretty, you went through everything, including me not allowing them to have both sides. So
Yeah, I'm pretty good. I think you did a good job at explaining it
Okay.
all. I'm good. Listen.
Okay, great. Well, thank you for being here. I'm glad we were able to make it quick and easy. And always don't hesitate to reach out and ask if you have any questions as you get going in this.
Will do, definitely. Thank you.
All right, thanks. Y'all have a great day.
All right, you too.